Hello viewers, today we are going to discuss the Honorable Supreme Court judgment with respect to ESI Act. The issue on hand with the dispute was the threshold limit. Before we discuss this judgment, just a recap on the provisions, the Act. Okay, ESI Act Section 1, very important. Subsection 4, it extends to all factories. So threshold limit is not applicable for factories. Please understand. Most of us make a mistake that threshold limit for factories and establishments are there. There is no question of threshold limit for factories. It applies to all factories. That is what Section 1, subsection 4 says. Section 1 subsection 5 of the ESI Act says that the appropriate government, either the state government or the central government, in consultation with the corporation, issue a notice of 1 month of its intention to bring about any establishment to be covered under the Act. Under this section only, the threshold limit was fixed for all other establishments other than factories to 20. And subsequently, these threshold limits were reduced from 20 to 10, 2011, if I am right. And there was one more subsection 6 of section 1 of the ESI Act, which was introduced in 1989, which says in case an establishment which is already covered based on the threshold limit, it shall continue to be covered irrespective of the fact that the number of employees have come down below the threshold limit. In this background, let us discuss this judgment. This case relates to ESI Corporation versus Radhika Theatre at Telangana. The facts of this appeal is that Radhika Theatre was operating since 1981 and is covered under the ESI Act. From September 1989, the number of employees strength fell below 20. Please recall the section 1 subsection 6. I said it was introduced in the year 1989, when the date is very important in light of this judgment. So in September 1989, Radhika Theatre strength fell below 20, so they stopped contribution, because at that point of time this subsection 6 was not there. This section was introduced with effect from 2010, October 1989. So when the strength fell below 20, before this amendment, obviously based on the reading of the plain reading of the section, they are out of coverage. Post 2010-1989, this ambiguity is very clear. Even if you fall below 20 or 10, as the case may be now, you still continue to be covered. Now what happened? The corporation issued a notice in 2003 and passed an order of recovery of dues from the establishment with effect from September 1989. Agreed by this, the Radhika Theatre challenged the same in ESI court, that the new amendment which came into effect only on 2010-1989, however, their strength of employees were below 20 in September 1989 itself. So they stopped paying. However, the ESI court did not agree with this contention and confirmed the notice and order issued by the ESI Corporation. Aggrieved by this order, Radhika Theatre challenged the same with the Honorable High Court of Telangana and contended the same, that new amendments shall be applicable only prospectively and not retrospectively. And at that time of their employee strength fell below 20 in September 1989, there was no provision of subsection 6 of section 1, and hence they are not covered under the new provision which came later in 1989. However, the corporation contended that this is a social welfare legislation, so a greater amplitude is required to be given. It is a welfare measure for workmen. However, the Honorable High Court did not agree with the contention of the corporation and quashed the notice of ESI Corporation. Agreed by the order of the High Court, the ESI Corporation went on an appeal with the Honorable Supreme Court. Supreme Court, after hearing both the parties, that is especially the ESI Corporation, the appellant, and also after studying the judgment of the High Court, it made certain observations and passed a judgment. Let us discuss the important crux of those judgments. I am quoting here. The Supreme Court says, having heard learned counsel appearing on behalf of the appellant corporation and having gone through the impeach judgment and order passed by the High Court, there are two questions. The short question which is posed for consideration of this court, that is the Honorable Supreme Court, is whether with respect to the demand notice post 2010-1989, a factory or an establishment established prior to 2010-1989 shall be governed by the ESI Act, notwithstanding that the number of persons employed therein at any time fell below the limit specified under the Act. The first question before the court. Then another question, an incidental question, which is also proposed for consideration of this court, that is the Honorable Court, where the demand notice for the period after 2010-1989, that is from the date by which the subsection 6 of section 1 of the ESI Act came into force, can it be considered to have been applied retrospectively? So these were the two questions before the Honorable Supreme Court. The Supreme Court went into the ESI Act and noted an act, what is the aim? See, every act will have certain preamble, aim. So as far as ESI Act is concerned, what is the aim and preamble? An act to provide for certain benefits to employees in case of sickness, maternity and employment injury, and to make provision for certain other matters in relation thereto. So the Supreme Court held that ESI Act being a social welfare legislation, any interpretation which would lean in favor of the beneficiary should be given liberal interpretation and should be interpreted in such a manner the social security and social justice can be done to these employees. The court went on to express further, even in the realm of the interpretation of a statute in general, rule of law is a dynamic concept of expansion and fulfillment. The law and the rule might have been from 1948, but it is dynamic, evolving, and the concept on the basis on which this law has come into force should be fulfilled, and in that manner it should be interpreted to subserve the social and economic justice as envisaged in the Constitution, the Supreme Court said. So, prior to the insertion of subsection 6 of section 1 of the ESI Act, only those establishments or factories engaged more than 20 employees were governed by the ESI Act. However, thereafter, subsection 6 of section 1 of the ESI Act has been introduced from 2010-1989. And after that, there is a radical change, and under the amended provision, a factory or establishment which the Act applies would be governed by the ESI Act, notwithstanding that the number of persons employed, because the ambiguity is now removed after introduction of subsection 6 of section 1 of the ESI Act. So therefore, for the demand notice for the period after 2010-1989, there shall be a liability of every factory or establishment, irrespective of the number of persons employed therein. Period. So with respect to such a notice, it cannot be said that the amended section 1 inserting subsection 6 is applied retrospectively. It is not that. The factory was in existence. It was covered. And when the strength fell below, there was no clarity. Subsection 6 was introduced. And in light of the welfare state and welfare measures as given in the Act, it should be considered to be implemented for the factory. So, as observed by and held by the High Court, the High Court held it is retrospective only in case of demand notice for the period prior to insertion of subsection 6 of section 1 of the Act. It can be looked at in that fashion. Only if it is for the before period, then it is okay. It can be said that the same provision has been applied retrospectively. Then it is okay. Therefore, the High Court had committed a very serious error in generally saying that it has been tried to be implemented retrospectively. That's not the question. So subsequently, to insert subsection 6 of section 1 of the ESI Act is applied retrospectively, and the High Court has erred in the appeal. That's what the Supreme Court said, and hence went on to further say that shall be applicable irrespective of the number of employees or the persons employed falls below the limit as specified under the Act, and set aside the order of the High Court. So the essence of this judgment is three important. Establishment covered under the ESI Act shall continue to be governed even the threshold limits fall below 10 or 20 as the case may be. Okay. And the ESI Act is a social security legislation, and a liberal view will be taken in favor of the employee's benefit. 2. Third, the demand notice covering period after 2010-1989 is valid. That means anything done before that and the notice issued for before that period is not valid. That is retrospective. This is prospective and applicable to all existing establishment that were existent and covered under the Act as of 2010-1989. Hope it's very clear. Thank you. We'll see you in another video.